Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, are there any federal anti-bullying laws or guidance?
Hi, Emily. Thank you for that question. While there are no federal anti-bullying laws, the United States Department of Education has sent a Dear Colleague letter to all boards of education throughout the country, advocating for a more forceful approach addressing bullying in schools. In the letter, the Department of Education has acknowledged that bullying fosters a climate of fear and disrespect that can impair the physical and psychological health of its victims and negatively affect learning. More tellingly, the Department of Education noted that certain student behavior that violates a school's anti-bullying policy could also trigger liability under federal anti-discrimination laws enforced by the department's Office of Civil Rights, or OCR. Within the Department of Education, OCR is responsible for enforcing federal statutes prohibiting discrimination based on race, color, national origin, sex, and disabilities within a school setting. While the OCR does not explicitly pursue discrimination claims based on religion, it has noted that many religious groups face discrimination on the basis of actual or perceived shared ancestry or ethnic characteristics, thereby invoking the civil rights statute that is covered by OCR. OCR has decreed that if a school encourages, tolerates, fails to adequately address, or ignores peer harassment based on the traits I just mentioned, at a level sufficient to create a hostile school environment, the school staff may be liable under the statutes enforced by the OCR. As a general proposition, a school may be liable if it fails to address harassment incidents about which it knows or should have known. The school may be deemed to be on notice if the harassment was in plain sight, widespread, or well known to the staff, such as harassment occurring in the hallways, recess, or on the school bus. The school may also be put on notice if a responsible employee knew or in the exercise of reasonable care should have known about the harassment. An example of this is when a student or another person informed the employee about the bullying and that employee did not inform the administration about the incident. The Department of Education letter sets forth 4 major responsibilities that schools must undertake to address discrimination against students in schools. First, when responding to harassment, the school must take immediate and appropriate steps to investigate the situation. Though the specific steps will depend upon factors such as the nature of the allegations, the age of the students involved, and the size of the school's investigation must be prompt, comprehensive, and impartial. Second, once the school determines that harassment did occur, it must take effective steps to end the harassment. Appropriate steps include separating the bully from the target, providing counseling for one or both of the students implicated in the matter, and taking disciplinary measures against the harasser. The letter also emphasizes that the school must not penalize the student who was harassed. Third, the school must take action to eliminate the hostile environment and its effects. To that end, schools may need to provide training or offer other intervention programs to the harassers, and on a broader level to students, families, and school staff in the larger school community. It may also be necessary for the school to issue new policies against harassment and reporting procedures to respond to the problem. The school must provide additional services to the harassed student, especially if the school was late to respond to the incident. Finally, the school must take steps to prevent future harassment and retaliation against the person filing the complaint. At a minimum, the school must reach out to the harassed students and their families concerning how to report future incidents, follow up with them regarding any new harassment actions, and promptly respond to related problems as they arise. A school is required to discharge these duties if the misconduct falls under the anti-bullying policy, regardless of whether the student complained, requested the school to take action, or claimed that the conduct was anti-discriminatory. If you have any questions about your child's rights related to bullying, please feel free to give me a call.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mayalaw.com, and please visit mayalaw.com for more information.